Good afternoon, Dr. Velasquez, classmates. My name is Daniel Hughes, and today I'm going to be discussing a case briefing on Craig versus Boren, governor of Oklahoma. As the governor or executive officer, Mr. Boren was actually named in the lawsuit. However, it is actually against the state of Oklahoma. The issue in this case is whether the state of Oklahoma violated the 14th Amendment Equal Protection Clause by denying the sale of 3.2% beer based on gender. In addition, a third party rights, also known as jus tertii, was examined by the court. In 1972, the state of Oklahoma passed a law banning the sale of 3.2 beer to males between the ages of 18 and 21. However, the law permitted the sale of beer to females of that same age group. At the time, the state tried to justify the law by a statistical study that showed that males between the ages of 18 and 21 were more prone to be cited for driving under the influence of alcohol and had more vehicular accidents. At the time, a man by the name of Craig Curtis, along with the ACLU, sued the state of Oklahoma for violating the 14th Amendment's Equal Protection Clause. In addition, a vendor who sold alcohol in Oklahoma by the name of Carolyn Whitner joined the suit as part of a third party rights. The U.S. District Court ruled in favor of the state by saying that the statistical data showed a relation that males of this age group were more prone to accidents and traffic tickets than females. And in the name of public safety, this law was justified. The court, the Supreme Court, heard the case in the fall of 1976, and a decision was rendered in December of 1976. The court ruled that the state of the court ruled that the state of Oklahoma did in fact violate the 14th Amendment's Equal Protection Clause of males between the ages of 18 and 21. It further added that the third parties acted as advocates because they were economically affected by such regulations. The state of Oklahoma overstepped their authority by discriminating against males of a certain group. The facts presented did not warrant a violation of Mr. Craig or any male within this category's constitutional rights. The men who are between the ages of 18 and 21 were deprived of their rights and deserve equal protection under the law. This case reinforced the notion that there is protection for all. In addition, the third party rights, or jus tertii, was clarified in this case that the owners were economically impacted, and it gave the vendor the rights to sue on behalf of all males within that age group. Moving forward, I'm looking or how my case uh, correlates to the readings that we are discussing this week is chapter 9. And in chapter 9, suing the government and its administrator is the topics. In doing so, I want to discuss how the chapter relates to the case. So after World War II, legislation and court decisions started taking on immunity uh, for public administrators or officials. Before that, they were getting away with murder, so to speak. However, things changed after World War II, and certain things like uh, sovereign immunity doctrine, where the government is solvent and cannot be sued for civil damages, was questioned. Government officers are not above the law, or government officials are not above the law. They have something called limited immunity, where government is protected by sovereign immunity, but it's limited. They also have what they call qualified immunity. Public officials have immunity, but are not absolute. There's a term, tortious administrative action, or tort, for short, where the people are liable for their actions. Um, However, this has gotten um, it's become a gray area because yes, you want to hold public officials accountable for their actions. However, um, the government has been turned into a mutual insurance agency because this is tax dollars that support or you have to compensate the liability for the employees, public employees' um, behavior. One of the ground, well, one of the issues that has really changed this in this topic has been Section 1983 of the Civil Rights Act of 1871. It allows people to sue the government for violating their civil rights um, or the misuse of authority they get from the states. So in 1971, there was a groundbreaking Supreme Court case called Bevins versus Six Unknown Narcotics Agents. Uh, Mr. Bevins was, or his Fourth Amendment rights were violated. However, they looked at absolute immunity and established qualified immunity doctrine. This actually opened the eyes and really looked at public officials being held accountable for their actions. However, this has taken a different twist nowadays. Public officials, especially police officers now, um, might be inclined not to do their job because of personal liability. Um, so when they make a decision, they might not make the decision at the best interest because of fear of civil liability. And again, like I said, this is actually going on, and I've heard many cases in law enforcement because they feel that if they do something that somebody doesn't like and they file a complaint against them, then an independent counsel reviews it and they can be liable for the damages. And not only the actual municipality, but the officer or the department itself. Furthermore, these cases prove that our Constitution is one, a living document, but two, it is protection for all. And at times, public officials do overstep their boundaries. Um, it is my belief that there needs to be some type of accountability for public officials. Yes, there's certain incidences or incidents where immunity comes into play, but it needs to be looked at on a case by case basis. Again, thank you for your time, and you have a nice day. Bye bye.